Ms. Murtaugh, you are correct. This has been a historical, I want to say, misinterpretation of what the court ordered. The court was very clear, at least verbally, when it ordered. I read the Minnesota Youth Hunt, and it's clear to me of exactly what I intended. I've had to clarify, I believe we've had various hearings, not only in this case, but the corresponding other matter with the other father and the other child involved. So I'm going to make this quite simple for everybody from here on out, so that there won't be any confusion and there won't be any complication, and the parties can hopefully do as Ms. Murtaugh has said, get along, figure it out. Appearances are all by video conferencing Zoom with approval of the court. We have Courtney Erickson appearing with Kate, or appearing by video. Kate Murtaugh, her counsel, appears by video. Adam Benson is hereby removed as counsel. We have Casey Madison appearing by video in the same office as his counsel, Jacob Gondik. We're set here today in this matter for a contempt hearing. The court has reviewed the motion and the affidavit for contempt. This is your case. Mr. Gondik, you may begin.
Thank you, Your Honor. I'd call Courtney Erickson to the stand.
Ms. Erickson, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you may begin.
Ms. Erickson, you have a child by the name of Cooper Madison with Casey Madison. Is that correct?
Yes.
And most recent order in the family law case that you're aware of is from June 2nd of 2022 from this honorable court. Is that correct?
Yes.
And you have a copy of that order?
I do.
And you've read that order?
Yes.
You've gone through that order with your attorney?
Yes.
Now, has there been some instances in the last year where you have not gone to the scheduled exchanges of bringing Cooper essentially to meet Mr. Madison so Mr. Madison could have his physical placement time?
There has been, yes.
And was one of those occasions on the weekend of March 2nd, 2023?
There was miscommunication, and their reading the order is not very clear. And I talked with my lawyer, and
Ma'am, that's
it
non-responsive.
was miscommunication.
That's not responsive to my question. Did you fail to bring Cooper to an exchange on March 2nd, 2023?
I was under the assumption that was my time with Cooper because it was
That is a
spring
yes
break.
or no? A yes or no, Ms. Erickson?
Yes.
And then after some communication between Attorney Murtaugh and myself, we came to the conclusion that that was going to be the makeup weekend for the youth deer hunt for 2022. Is that correct?
Yes.
Okay. Now I'll direct your attention to the weekend of August 18th of 2023. Did you fail to bring Cooper to the exchange on August 18th of 2023?
Yes, I did, but it was.
Okay, thank you. And regarding that exchange, you're aware that Mr. Madison actually drove all the way down to Wyoming, Minnesota. Is that correct?
I assume he did,
Okay.
but I have no proof that he did.
Okay. If he says he did, would you believe him?
Yeah.
Okay. And you guys actually, you and Mr. Madison actually exchanged text messages regarding this. Is that correct?
Yes, we did.
Okay.
Like I said, I was under the assumption I kept him, and I had lost my mother-in-law 2 days before that, and there was a lot going on.
Okay. And I believe you actually said that in a text message, right? That there was a lot going on. Do you remember sending a text message to that sort to Mr. Madison?
Yes, because I had just lost my mother-in-law.
Okay. And I believe you also stated in that same text message something to the extent of that was the last thing on my mind.
I told him I was under the
Is
assumption
that a yes or a
he's,
no, ma'am? Is that
I
accurate, what I
was,
just stated?
can you restate your question?
In the same text message that I was previously referencing where you texted Mr. Madison, you also said that exchanging Cooper was the last thing on your mind. Is that correct?
I believe I stated that I was under the assumption he stayed home that weekend because it was the weekend before school started, and that I was under the assumption he stayed home. And digging in the order and trying to review the order was, yes, the last thing on my mind. But like I stated, I thought he stayed home.
And that's because, as you stated, you had a lot going on that week, right? You could say, would it be fair to say you were stressed out?
Like I said, I assumed he stayed home. So I was under the assumption he was staying home that weekend because it was the Friday before school started.
Okay. Ma'am, you do understand now you've given two different explanations, right? That one, you were confused on the order because regarding the summer schedule turning into the school year schedule, right? That was one of the explanations.
Yes,
Okay.
I
And
assumed he stayed home because it was the last Friday before school started.
thank you for answering my question. And then the other explanation is because you were stressed out and you had a lot going on. So that was the last thing on your mind.
Trying to figure out the order and dealing with Casey.
Was that the other
I
explanation,
wasn't
ma'am? Was that an accurate
ready for that, and
interpretation
I
of the other?
wasn't in the state to deal with that.
Okay. In the future, when you get stressed out, are you going to look at the order or just not bother to exchange Cooper to Mr. Madison?
I feel like a death in the family and a very close death of the family is a big deal.
Ma'am, I didn't say it is or it isn't. I just said when you get stressed out, how about this question? Strike that. Are you going to at least communicate in advance to Mr. Madison so he doesn't have to travel 3 hours and 45 minutes one way to just, I guess, be stood up and not get his child at the exchange?
Casey was aware that my mother-in-law was not doing well. He actually met me a little bit early, a couple weeks before, because he knew she wasn't doing well. I guess no, I didn't let him know that she had passed away.
You didn't let him know that he was not going to get Cooper at the exchange on August 18th, 2023. Is that correct?
I was under the assumption that was my time.
And that was after you gave a text message explanation that that was the last thing on your mind. Is that correct?
Fighting with Casey, yes, was the
Objection,
last thing
Judge.
on my mind.
He has asked this question multiple times and she's answered.
Asked and answered. Move on, Mr. Gondik.
Okay. And then did you have subsequent conversation with Mr. Madison in text message form after August 18th, where he ultimately said that can be your makeup weekend for the 2023 Minnesota Youth Deer Hunt?
Objection, irrelevant.
I'm gonna allow it. Please answer.
He sent me these text messages. It was either the day that my mother-in-law died or the day after my mother-in-law died. It is very stressful to communicate with Casey, and just agreeing to whatever he wants is what's best. He lost out on 2 days with Cooper. Yes.
Okay, so you had a text exchange after that regarding the fact that that could be the makeup time for the 2023 Youth Deer Hunt?
2 of the days, yes.
2 of the days. A weekend consists of 2 days, you'd agree, right?
A weekend is 2 days, yes.
Okay. Now, you ultimately ended up sending Mr. Madison a text message where you stated 30 days in advance per the order to your credit that you wanted to keep Cooper December 8th through, I believe the weekend of December 8th until exchange would be December 10th on a Sunday. Is that correct?
Yes.
and Mr. Madison, and you disagreed regarding that weekend because he stated you already used that weekend of August 18th. Is that correct?
Yes.
Okay. However,
I,
you withheld Cooper on December 8th regardless.
for the year of 2023, Casey was granted 4 days for the Minnesota Youth Hunt. It was a Thursday and a Friday and Saturday and Sunday. I used 2 of the days for my mother-in-law's funeral, and for the Thursday and Friday, I used that for December 8th weekend. So he lost out on 2 days for the December 8th weekend. He lost out on 2 days for my mother-in-law's funeral, and I got those days back. Or he used 4 days, I used 4 days.
But a weekend only consists of 2 days. Was the Thursday, Friday leading up to the weekend of the Minnesota Youth Deer Hunt? Was Cooper off of school?
He was. So Casey was granted 4 days. I am entitled to make up time for those 4 days, which I used 4 days.
If, ma'am, and I think obviously this is where some
I think you're
confusion
objecting
stems-
because she's acting as if she's a lawyer and is making a legal determination of what the law is. She has a lawyer who can do that.
and essentially only the Honorable Judge Mogan here today is going to make that determination regarding that interpretation. I think that's stipulated and agreed upon and well known. Ms. Erickson, you intentionally did not bring Cooper to these exchanges, is that correct?
The weekend my mother-in-law died, no. The other weekend of December 8th, I gave him a 30-day notice and I texted him a few days in advance.
And you intentionally did not bring Cooper to Wyoming, Minnesota to the exchange, is that correct?
Objection. He's asked and she's answered.
It's asked and answered. Sustained.
Ms. Erickson, are you going to continue to disobey the order moving forward?
I think that there is some
Okay.
clarification that needs to be done. And I think,
Unresponsive, and the court will make an order and a decision as it relates to that, and I will make sure that the parties are very clear on what my order is.
No further questions for Ms. Erickson. Thank you, Your Honor.
Ms. Murtaugh.
So, Ms. Erickson, there are 3 issues here. One is from March 2023, that's spring break, correct?
yes,
Did you rely on the advice of counsel when you made your decision about that weekend?
I did.
Ms. Murtaugh, I am going to caution you, if you're asking her about advice on counsel, that opens it all up to attorney-client communication. Do you want to do that?
Well, Your Honor, I will just tell the court, I did give her bad information, and I guess that's really all that I was getting at. So that's as far as I was gonna go. And
Okay.
I admit that I gave her, and I told Attorney Gondik, I gave her incorrect information.
Well, it takes a lot for an attorney to admit that, Ms. Murtaugh. Thank you.
So we're gonna move on now to the August 18th, 2023 situation. So did you intentionally deny Casey that time?
No, I did not.
So what I heard you testify to is that you did not understand the order and that you were stressed out and that you did not look at the order before making your decision about how to handle that August 18th, 2023 weekend. Is that right?
Yes, yes,
Now, moving to the December 8th through 10th weekend, you did give you did give Casey the 30 days notice required, correct?
yes.
And did he tell you you didn't have any time to use at that point?
Yes,
Do you believe that at that point you had makeup time?
I believe I did, yes.
And so you you kept Cooper for 2 days, true?
Yes,
Objection leading.
I'll allow it.
And as far as you're concerned, between the 2022 youth hunt time and the 2023 youth hunt time, and considering the spring break, so the March time, the August 18th, 2023 time, and the December 8th through 10th, 2023 time, considering all of that, how do you think that you owe Casey days, or do you think that Casey owes you days?
day for day, I feel like I am still to the good 2 days.
So as far as you are understanding at the moment, you feel that you still have 2 makeup days to use for those 2 youth hunt periods.
Yes.
I don't have any other questions.
Any redirect, Mr. Gondik?
Just briefly, Your Honor, Miss Erickson, you get substantially more time in the course of a calendar year than Mr. Madison. Is that correct?
Objection irrelevant.
Sustained.
Your Honor, just brief argument then. That's all I'm gonna display for my case.
All right, you don't have any, you're not gonna call Mr. Madison?
Actually, I will call Mr. Madison for a few questions. Casey, can you raise your right hand?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may begin.
Mr. Madison, what are you asking the court here to do today?
I'd like some reimbursement for travel time, makeup weekend for time lost, and attorney fees.
In addition to that, Mr. Madison, would you be asking the court to find Miss Erickson in contempt so that she can purge her conduct moving forward?
Yes.
What is the main goal of bringing a contempt motion like this?
Objection.
Sustained.
That's it regarding Mr. Madison.
Ms. Murtaugh.
Mr. Madison, it's your contention that you drove to Wyoming on August 18th, 2023 for the exchange, correct?
Yes.
You did not, however, drive on December 8th, true?
I drove part way, not all the way, yes.
Okay, you did send a text message to Miss Erickson saying Zach will be at Casey's at 6 tonight to pick up Cooper, correct?
Yes.
No other questions?
All right, redirect, Mr. Gondik.
Mr. Madison, regarding the expense of traveling down to Wyoming, Minnesota on August 18th to not essentially get Cooper, what would you estimate your travel expenses to be on that day?
Probably $60, $80 gas.
And that's a tank of gas for going about 200 miles one way, is that correct? And so essentially 400 miles round trip.
Yes.
No further questions, Your Honor.
Ms. Murtaugh.
One moment, Judge. I don't have any other questions.
Okay. Argument, Mr. Gondik.
Thank you, Your Honor. Regarding contempt, as we all know, it has to be an intentional disregard or disobedience or resistance of a court order. There is no surprise here. I think even to Miss Murtaugh's question, Attorney Murtaugh's question, Miss Erickson answered that, there was a failure to look at the order. I mean, that is an intentional disregard to obey the order. These orders are in place for a reason. We don't want to waste the court's time. If she's not going to at least look at the order to see when she has to bring her child to an exchange, I mean, that is a problem. Ultimately, Mr. Madison is driving a significant distance. He accumulates a fair amount of expense. I don't think it's joyful for him to have to retain my services to be able to bring a motion like this when really all he wants is the order followed so that he can continue to have his weekend placement with his son. Regarding that, I think it's obviously an intentional disregard. We would ask that the court find Ms. Erickson in contempt regarding that, to pay attorney's fees of $500, travel expenses of about $70, and then order a makeup weekend. And in addition to the attorney's fees, the personal service costs as well. Thank you, Your Honor.
Thank you, Ms. Murtaugh.
So, Judge, I think it's important. One, Attorney Gondik said that Mr. Madison wants time with his son, and the court heard a whole lot of testimony at the trial. From reading the order, I know I don't have the same historical knowledge that the court does, and perhaps Mr. Gondik, but this is their child. Cooper is their child, and there's an obligation for the parents to work together on this. I'll just say, regarding the March 2nd, 2023, Ms. Erickson, in no way did she intentionally or willfully violate the court order in the manner that is required for a finding of contempt. I gave her bad advice on March 2nd. With respect to the August 18th, I do understand certainly Mr. Gondik's point that she didn't look at the order. People make mistakes. People make mistakes. It doesn't mean it's intentional. It doesn't mean there's a disregard for the court. And it certainly doesn't mean that she's trying to thwart any time or harm the relationship between Mr. Madison and their child. People make mistakes. That's what that was. There was a lot going on. She was stressed out. Regarding the December 8th through 10th weekend, the court heard her testimony that she gave the 30 days notice, and as far as she's concerned, she is still entitled to 2 makeup days. Now, I know the court said that the court will make a decision on that issue, and I think that will be really helpful. I don't think there's enough to find that she willfully and intentionally violated the order. At the very least, there is a problem with interpretation, and I think that that's just evidenced, Your Honor. Last, for the Youth Hunt 22, Attorney Gondik sent a letter to the court literally entitled clarification of the order. So if Mr. Gondik doesn't understand it, and I don't understand it, and give advice that is not consistent with the order, I don't think that it can be intentional. So I would just ask that the court not find her in contempt, and there is a need to clarify some of the orders, and that my understanding is that the court will do that today.
All right, thank you. Ms. Murtaugh, you are correct. This has been a historical, I want to say, misinterpretation of what the court ordered. The court was very clear, at least verbally, when it ordered. I read the Minnesota Youth Hunt, and it's clear to me of exactly what I intended. I've had to clarify, I believe we've had various hearings, not only in this case, but the corresponding other matter with the other father and the other child involved. So I'm going to make this quite simple for everybody from here on out, so that there won't be any confusion and there won't be any complication, and the parties can hopefully do, as Ms. Murtaugh has said, get along, figure it out. You have a child here who sees all of this, who hears all of this, who knows the contention and the disruption and all of the aggravation and frustration between both of the parents. This isn't something new. This is something that has started probably from day one. We had a very lengthy trial in this case, it's very clear that very clear from not only the testimony here, but from previous hearings, that Ms. Erickson does what Ms. Erickson wants to do. It is very clear. I do find that she intentionally violated the agreement. She intentionally did what she wanted to do. She disregarded what the court ordered. And again, I'm not only looking at this date and time, but previous, and that's why I'm going to modify my order. And this is the very reason why I'm doing that. I do believe that Ms. Erickson, you owe your attorney, quite honestly. She took the hit for you, and she is willing to stand in front of a court and say, I messed up. I messed up and I gave her the wrong advice. So with regards to that one, I'm going to give you a little bit more leeway with that violation, because your attorney is covering you with the grenade, so to speak. But I do believe that Mr. Madison is entitled to at least the gas to be made up, because there was no notification to him. He drove, he was there. So at the very least, as it relates to the March date, I am finding that Ms. Erickson must reimburse Mr. Madison $70 for his gas, because I'm doing the middle ground. He said probably $60 to $80. I didn't get testimony, quite honestly, with regards to if it was a truck, the gas mileage, the miles per hour, the cost of the gas, or anything of that nature. So I'm just gonna go off of what I have, because I do believe that there should be some reimbursement, at least for the gas. I'm not going to have you pay for his attorney's fees to bring this motion, although I probably should, because we're not dealing with one incident. We're not dealing with two incidents. We're dealing with 3 incidents, which the court finds reprehensible, quite honestly. So what the court is going to do with regards to the Minnesota Youth Hunt, making it very clear, both parties will have no ability to misconstrue what the court is saying and what the court is ordering. Mr. Madison will be entitled to the weekend of the Minnesota Youth Hunt every year, including Thursday, Friday, Saturday, Sunday, every single year. Ms. Erickson will no longer have any makeup weekend as it relates to that. No makeup weekend, none, zero, zilch, none. That is removed. That is the penalty for the continued violation of this contempt. What the court will do is, I will also state for the record that as it relates, she made some statement of the weekend, the before school, the Friday. I didn't know if I had to comply with that and provide him with the weekend. I don't know where she was going with that. I don't know what that means or entails, because I have reviewed this order and I see nothing that says mother gets the weekend before the school starts. What I do see is the school define the school year as the school year shall be defined as commencing on the Friday before the first day of school and shall end the last day when school is in session. Still, it would still mean that whoever has the normal placement on the Friday before school and that weekend, it's that weekend. Doesn't mean that even if it's Mr. Madison's time, that because it's set, the court defined the school year as that definition, that she would be entitled to the weekend before school starts. That is not the order of the court. So to be very clear, again, I am modifying the Minnesota Youth Hunt. I am not providing Ms. Madison with any makeup time. It's very clear. It's very clear in what the court said, weekend. It is a weekend. Now, whether or not they wanted to interpret it to be Thursday and Friday, that's for the parties to decide. And I'm not saying that Mr. Madison had the ability to have Thursday and Friday previously, because that's not what the court ordered. It is a weekend. So if he historically had Thursday and Friday, that was between the two, and they should have figured that out, but they didn't. And so that is what the court is going to do. I believe that is all I need to cover. The expenses of $70 with regards to Youth Hunt, the court has modified its order. I believe that's all. Mr. Gondik.
Judge, you want me to do an order to that reflect, or is the court going to, or how would you prefer we go from here?
Order, please.
Yes.
Ms. Murtaugh.
I'm assuming Mr. Gondik will send me the order to approve.
He
That's all.
will, before it's
Yep.
filed with the court.
Thank you.